Good morning and welcome to the Public Service Commission of South Carolina. We are here today in docket number 2022-351E. This docket concerns the application of South Carolina Public Service Authority, also known as Santee Cooper, for approval of a competitive procurement program pursuant to South Carolina Code Annotated Section 58-31-27. We originally held a hearing in June on the application, and today we are here to hear from the Commission's outside consultant on the program proposed by Santee Cooper, and then I think we have some rebuttal testimony as well. Let's take a roll call of commissioners. With us virtually, we have Commissioner Irvin. Present in the hearing room, we have Commissioner Justin Williams, Vice Chair Powers, Commissioner Thomas, Commissioner Carol Lee Williams, Commissioner Caston, and Chair Belser. Let's take appearances from the parties. Who's here representing South Carolina Public Service Authority, also known as Santee Cooper?
Good morning. Steve Pelcher. With me today are attorneys Megan Driggers, Alex Brazell, and Ashley Cooper.
Thank you, Mr. Mr. Pelcher. I'm going to need you to talk into that microphone if you have to talk from your desk.
Okay.
And is there anyone from Central Electric Power Cooperative Incorporated? Not yet. Office of Regulatory Staff.
Thank you, Madam Chair, members of the Commission. Ben Mustian. With me today is Nicole Given on behalf of ORS.
Thank you, Mr. Mustian. I think the procedure that we'll follow this morning is I noticed that the consultant is in the hearing room, Mr. Janicek. It's good to see you this morning. We will hear from our outside consultant, Mr. Janicek, with PA Consulting Group, and then he will be available for questions from the parties and from the commissioners, and then if there's rebuttal testimony, we will hear from that then. So that'll be our order of procedure. If anybody has any objection to that, you better speak now. So, Mr. Janicek, welcome, and I'm going to ask you to come forward, please. We'll put you at the table down here. I'm going to need for you to turn that microphone on. There's a button at the bottom. That's on. And you may have to adjust it so that we can all hear you and you can be heard in virtual space too. Welcome this morning.
Thank you. Good morning,
Good morning.
Madam Chair, Commissioners.
I'm going to ask the court reporter to swear you in, if you would. Raise your right hand, please.
Do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Mr. Janicek, this is a little bit different proceeding than when you've got a lawyer asking you questions, but I'm going to ask you if you would just summarize and present your report. And while we're at it, you filed this report, I think, on July 6th. Is that right? And it's about 35 pages long.
Correct.
Including front cover and back cover. And so we will enter his report as filed as the next hearing exhibit, which I think will be hearing exhibit number 3. So we will take the consultant's report and mark that marked for identification as hearing exhibit number 3 and enter it into the evidence of this case. And you may proceed with explaining your report to us. Thank you, sir.
Great. Thank you. Good morning, all. I am Charles Janicek with PA Consulting. We have developed our independent review of the applicant's application for a competitive procurement of renewable energy program, which was mandated by Act 90 of the South Carolina Legislature. As Madam Chair just mentioned, our report was filed in the docket on July 6th, 2023, and the report contains our review of the application and identifies a number of issues that we think are a little bit deficient in the applicant's program, and we think that these are topics for the Commission to consider as it's considering whether or not to approve or reject the application and the program guidelines as submitted. I think that our report speaks for itself. I'm happy to answer any questions on the report.
Thank you, Mr. Janusik. Santee Cooper, any questions for the witness?
Yes, Chair.
Ms. Brazil is recognized, and I know it is human nature to look at the person that's asking you questions, but I need for you to talk into that microphone, Mr. Janusik.
Sure.
Good morning, Mr. Janusik. I'm Alex Brazil, and I'm here on behalf of Santee Cooper. And I just have a couple of questions today for you, and most of them relate to the timing of the recommendations that you submitted in the report on page 34. So I'll kind of walk through those, and really it's just to get some clarifications. Okay, so you understand, and I think you've referenced in the report, that Santee Cooper's guidelines can be used in connection with a specific RFP, correct?
Correct.
And those guidelines are just a framework that will then give Santee Cooper the flexibility to, tailor, to a specific RFP or some sort of procurement objective. Correct?
Correct.
And so if you go ahead and look at the recommendation on page 34, it's going to be, I'm going to kind of start backwards. Do you have the report in front of you?
I do.
Okay, great. Let me get to it. 1 second. Okay, so I'm going to first look at 5B, and it says Santee Cooper may also consider releasing an all-source RFP as performed in the past. Do you see that?
I do.
And so I just want to get some clarification of where it says that you're not recommending that Santee Cooper incorporate this specific recommendation into the guidelines, are you?
So I think that the whole point of this program, and recognizing that the program itself is for the competitive procurement of renewable energy, but we looked more holistically at the Act 90 and the enabling legislation that required this program. And it's our view that what they were really trying to get at is the Act 90 established the oversight and the authority of the Commission to regulate Santee Cooper's procurements. And we really feel that this is an opportunity for the Commission to establish this lasting framework. This is the first time that the Commission has had the authority to oversee these procurements, and we really feel that it's important that the Commission establish a strong framework going forward that is very prescriptive around the different types of procurements and RFPs that the authority, the Santee Cooper, will be conducting in the future. So this is an opportunity for the Commission to establish these, and so that's why in our recommendation and in our report in general, we do make some comments and some recommendations around specific RFPs rather than the broader, more generic program. But I think that it would be beneficial for the Commission and for the Santee Cooper's ratepayers, customers, to have this framework be solidified and identified more clearly now, rather than waiting for the program guidelines to evolve in the future.
But I do think, and I just thank you for that. I guess my question is, though, that the guidelines as submitted, they do provide the flexibility for Santee Cooper. Say they do need an all-source RFP. It does. The guidelines themselves would provide Santee Cooper the flexibility to issue such an RFP.
Correct. The guidelines do They provide the flexibility for Santee Cooper to issue those RFPs in the future, different types of RFPs. But what we found in the the initial draft of these guidelines is that there's not a lot of specificity around what those RFPs should contain, and so we tried to, in our review, look for areas where the program guidelines might be able to be more specific and provide more specificity around what those RFPs are going to contain, rather than leave it and say, in the future we might do this, which is how we interpreted the program guidelines.
You would agree that once Santee Cooper identifies a certain need in their planning process, though, that they could that need is going to determine what the RFP looks like.
Well, maybe. I think that there's the IRP planning processes, and I'm very familiar with how they work. They typically identify a certain type of need, but I wouldn't say that they identify a certain specific type of technology, or they don't need to. And so that's why we recommended considering broader, more all source RFPs, rather than targeted to a specific type of technology or even location. In some cases, you do have a very specific locational need, and that's understood. But in terms of more system-wide power, we feel that holding, as a general rule, holding broader, more inclusive RFPs rather than specific targeted RFPs tends to have better outcomes, because it's going to lead to more competition, potentially lead to solutions or bids that perhaps hadn't been identified in the IRP, and yet when they are proposed, and when Santee Cooper does its modeling to incorporate the potential of that resource, it may turn out that resource type might be more beneficial to the system. And if you have a targeted RFP that restricts other types of technologies, you might not get that bid come forward.
And I do think, so, kind of circling back on the various criteria that I think that you've set forth, and I do think that in the report itself, you all acknowledge, PA Consulting acknowledges that the guidelines themselves provide at least 15 different criteria that can be used once there is a specific identified need, correct?
They do identify in broad terms a number of criteria that would be considered in the evaluation of the bids. I think it's in the plan on page 12, where it lists, I think it's 15 factors that will be considered. Our feeling is that while those topics are identified, the application was light or silent on details of how they would be considered. One of those would be the ability to extend extreme weather. That was identified as a factor, as a consideration that bids would be measured against, but no specificity, no details on how the Santee Cooper would evaluate the ability to withstand extreme weather. And so there's other examples too, readiness and viability. I will say that in other RFPs that we have worked with in other jurisdictions, they're often in the RFP itself, before it gets released to the public and to the developer community, will contain scoring criteria containing detailed factors that are going to be looked at for each one of those evaluation criteria. And we recommend that some of that get get incorporated into these program guidelines so that the commission can have a better idea of how Santee Cooper is going to evaluate for these factors, rather than just listing the factors themselves.
And I want to change gears slightly here. You're aware that Santee Cooper issued a prior RFP?
I am.
And are you aware that many South Carolina solar developers participated in that RFP?
I am.
And none of them filed comments or intervened in this proceeding that you're aware of, right?
I don't believe so.
Okay. So I want to turn to addressing recommendation 1 following that line of questioning here. And recommendation 1 discusses elongated discovery processes. And I think, do you think it's fair to say that if there were discovery issues in the prior RFP, some of those solar developers may have filed comments in this docket?
They may have. I have a couple of thoughts there. I would say that the developer community is always evolving. I believe that prior RFP was in 2020, and so I would imagine it's highly likely that there are other developers who may participate in a future RFP who did not participate in that 2020 RFP. As well as, I think that I wouldn't. It may have been using the phrase elongated discovery process. What we really were getting at was, in a number of RFPs that we've seen in the past, if there's not enough very specific detail in the RFP about exactly what Santee Cooper is looking for, then you get into a situation where when you get the bids come in, there's sort of an incomplete understanding on the part of Santee Cooper of exactly what the bidder is proposing, or some nuances of their bids, situations like that. And so that can lead to Q&A back and forth. And although the timeline of that Q&A might fit within the required timelines of an RFP, so perhaps not excessively elongated discovery, it can sometimes lead to miscommunication, misunderstanding of what the actual bid is proposing, and it also leads to the potential, the more Q&A that needs to go back and forth between the utility and the bidders, it leads to the potential for unintended bias on the part of the utility to characterize a bid in a certain way that perhaps was not the original intent of the bidder.
And I think that all makes perfect sense, and I agree with the need to provide more detail. I'm just I think my question's more along the lines of the timing of that, and wouldn't you think, or wouldn't you say that most of that detail would come, for the specific RFP versus the guidelines now?
Well, I think that regardless of the type of RFP, there certainly is a minimum, a very common set of criteria that every RFP is going to request of bidders. And regardless of the technology, certainly around non-quantitative information. If you're asking for a certain type of resource, you're going to ask for a certain type of data around that resource. But there's also a lot of sort of non-price and qualitative factors that the Santee Cooper mentions in its application. Being able to be more specific about what each individual bidder needs to provide, I think that there's a lot of that information that would be common across all RFPs, and I think the commission would benefit from having that sort of documented in the application, in the program guidelines, just so that they know that going forward, at a minimum, all RFPs are going to contain this type of request from the bidder.
Thank you. I think the last item that I want to cover is recommendation 2BI on page 34, and it relates to recommending an additional independent third party. And I think on this, your recommendation is to have an additional third party to a third party that Santee Cooper may use to assist it with the CPRE process, right?
Well, our recommendation is for an independent evaluator or observer or auditor. The phrases are different depending on the very specific scope that is given to that third party. But to be an independent party who is not involved in the evaluation of the bids, but is or of the whole entire process, but is involved in providing an independent review of the procurement process. How well were the bids evaluated according to the published methodology? Things of that nature. Recognizing that Santee Cooper in the prior RFP used a third party consultant to assist with the administration in the evaluation of those bids. Our view is that's a third party, but it's not an independent third party. It was working at the direction of and in collaboration with Santee Cooper, rather than being a truly independent observer.
And did you identify any sort of, identify who would bear the cost? Say Santee Cooper had their own third party, and then there was an additional independent third party. Did you all identify who would bear the cost of that additional third party?
Well, in the big picture, those costs, the cost of an independent, we'll call it an independent observer, ultimately are going to be borne by ratepayers, whether or not that independent observer contracts directly with Santee Cooper or contracts directly with the commission. It's all public, right? So I think different contracting mechanisms are used in different jurisdictions. Sometimes the independent observer will contract directly with the utility, but actually be in effect working for the commission or the commission staff. And so in other cases, the independent observer can contract directly with the commissioner. But in a case of Santee Cooper, which is a publicly held utility, it's all going to be borne by the ratepayers at one way or another, right? And so that's where the cost would come from. I would say that given the size of procurements and given the investment and the commitments that Santee Cooper and other utilities are making whether or not they purchase facilities for utility ownership or whether they do PPAs, power purchase agreements, they're still committing to a certain level of funding for that PPA for the life of the PPA. The cost of an independent observer is a very small fraction, in most cases, 0.0001% of the overall cost of the procurement. And so when we think about the benefit to the commission and to the South Carolina ratepayers, it's very cheap insurance to have that additional level of independent observation relative to the size of the investment or the commitment that the utility is making.
And I guess regardless of which jurisdiction, but in this situation, when you all did your review, you didn't take into account who would bear the cost for this recommendation.
Well, I think it would be either the commission or Santee Cooper, both of whom are publicly funded.
And in making the recommendation for this additional third party too, you all didn't perform any sort of cost benefit analysis, did you?
In terms of a specific cost benefit analysis, no. Generally, because we think it's at the commissioner's discretion to define the scope and the precise duties that independent observer would conduct, and so without knowing that, it's very difficult to estimate a cost. But as I said, in all of our independent evaluator work in other jurisdictions, we can say that the cost of the independent observer contract is far less than 1% of the total cost of the procurement.
Okay, let me look at my notes. I think that may
Sure.
be all I have for you, but give me 1 second. Okay, I think I have one final question for you, Mr. Janicek, so thank you. Going back to the solar developers in South Carolina specifically and whether or not they've intervened, I think you testified that you were aware that they had not intervened in this docket or filed comments. Is that correct?
Not that I'm aware of.
And so none of them filed any sort of recommendation that there needed to be an additional third party for any future RFP that Santee Cooper had issued.
Not that I'm aware of.
Okay. I think that's it. Thank you so much.
Thank you.
Thank you, Ms. Brazil. Did anyone from Central Electric Power Cooperative join us? Hearing none. Office of Regulatory Staff, any questions?
No questions.
Commissioners, questions for the witness? Commissioner Carol Lee Williams.
Thank you, Chair Belzer. Good morning. It's good to see you in person.
Good morning, Chair Williams.
I'm going to follow up on Ms. Brazel's questions with regard to the independent observer, third party. And you may have answered this. Who hires that person?
Well, in my experience, it's done differently in different jurisdictions. I'm aware of states and jurisdictions where the commission, the State Public Service Commission, directly hires with the independent observer. In other jurisdictions, the contract, the hiring process is done by the utility, but subject to commission approval. And the commission will approve the selection of the independent observer or evaluator. And the contract is with the utility, so that they fund the third party. But in practice, it often tends to be that we work more closely with the commission staff in that case, more than the utility, because if we're working to provide an independent observation, we're not really in practice working for or at the direction of the utility, much more so the commission and staff.
Okay. And is this a recommendation that is a one-time learning experience to kind of set us off on a better foot, or is it every time there is a CPRE undertaken?
Well, that's certainly up to the commission's discretion.
Well, I'm asking for your recommendation.
I would say that our recommendation is that for a certain threshold of procurement, right? There's a lot of times where a utility may go do a 30 or a 90-day purchase power agreement, some trade or something. Wouldn't recommend an independent observer for something like that. but any sort of sizable procurement, to be determined what that size looks like, I would recommend an independent observer. And in our experience, that has been utilized by other jurisdictions around the country. In those jurisdictions, there certainly are certain types of procurement that are not subject to the independent observer rule. But generally, any major procurement, 500 megawatts, 1,500 megawatts of solar, as the IRP calls for, would fall into the independent observer requirement.
So those examples that you just gave me of megawatts, is there a rough number that is sort of a minimum? It kind of gets back to her question about cost benefit, which I think you're evaluating as you present, as you answer questions. Is there a minimum wattage, megawatt threshold that generally would produce positive results?
Yeah, it's a good question. I would say that, without wanting to define that right now, I'd recommend that any type of utility scale long-term procurement, so maybe something on the lines of 100 megawatts or larger. Lots of times a utility might do some special contracting with qualified facilities. There's all sorts of smaller procurements that a utility will often engage in, and it's probably not worth the cost benefit to require an independent observer for every single procurement. But subject to the commission and the utility agreeing on a certain threshold limit, I would argue that any major, any sizable, could use 100 megawatts or larger procurement would be subject to this requirement. And with the caveat that you wouldn't want to get into a situation where the utility then goes and does a bunch of 99 megawatt procurements, right? Within reason.
So my observation of you is that you kind of came up to the 100 megawatts because I asked the question, but I don't want to, that's what I'm assuming just based on this conversation. Is that based on best management practices? Is it based on, a general rule of thumb based on your experience? Tell me more about. You admitted you were kind of producing that number because I asked.
I was. I really was more comfortable suggesting a utility scale procurement. And that phrase utility scale doesn't have a very super precise definition, I would say. I don't think that when we think about solar facilities, when we think about generating facilities, usually anything in the 50 to 100 megawatt range could be considered utility scale or not. It gets defined differently. As you get north of 100 megawatts, it's generally accepted that would be considered utility scale. And so I think that would be something that the commission would want to sort of take comments on, and maybe work with the utility and the Office of Regulatory staff to decide on a very specific threshold, because I think that every procurement's a little bit different, and some procurements definitely wouldn't require it. I use the example of short-term trades, and somewhere between short-term trades or 90-day procurements up to a long-term 100 megawatt and above procurement, that's where the line would be crossed to require an independent observer.
When you talk about 99, 100 megawatts, are you talking AC or DC?
I generally speak in terms of AC.
Okay. you may have covered this earlier, and this is changing gears, but did you discover anything that made you use the term elongated discovery process? And I believe you probably did have that conversation, and you said maybe that wasn't the best word.
Well, what I meant is we were really the whole point of that was to get at the fact that the more specific that RFP instructions and required information, the more specific they are, the less opportunity for a whole lot of Q&A back and forth between the utility and the bidder. Even in the 2020 RFP, and I think it was in Mr. Painter's testimony, he mentioned that there would be Q&A back and forth between the utility to better understand. No RFP is going to be perfect, and there's always going to be nuances. I've never seen. I can't think of a situation where a bid was just completely accepted without any follow-up whatsoever. Everything was perfect. Every bit of information was perfect. There usually is a little bit of Q&A and a little bit more clarification questions that go on. But if I have seen RFPs where they were so broad and so vague that Q&A process was elongated. It lasted a long time. It may not have violated a certain timeline aspect, but it just added more complexity. It added more work to the utility, frankly, to understand exactly how to incorporate this bid into their evaluation methodology.
Well, that kind of leads to something else that you just talked about, and that is the recommendation for all source, but based on a need identified in the IRP, is there a way to kind of create the world where you're open and you're trying to discover a bid that you wouldn't otherwise get, but still be very clear what's in your IRP and what you think you believe you need? Is there a way to do both, is what I'm asking.
Well, I think there is. I think that, the IRP, including the Santee Cooper IRP that was issued this year, it was very clear on exactly what types of resources it would be looking for, that its system needed. And I think that the development community, if they're bidding into a Santee Cooper RFP for resources, I'd say they almost certainly have read that RFP and they understand how those needs were identified. But I don't think that there's necessarily always a reason to specifically target an RFP to a very specific technology. It just tends to limit by definition, it limits the types of bids that you're going to get. It probably limits the number of bids you're going to get. And in some cases, there are very good reasons for issuing a very targeted RFP. In my experience, that's been more the case when there's some locational aspect, it tends to be transmission or distribution system related, where there's perhaps a constraint in a very specific location that they need some generation or some solution there. That makes sense to make it very targeted. But in general, I think it makes a lot of sense that the broader that RFPs can be, the needs and the broader the request of an RFP, almost by definition is going to lead to greater competition, greater interest from developers, and to the extent that in some cases, if there's a mandate for a certain type of technology, in a lot of states, they have renewable energy requirements where they need to procure that much renewable energy or energy that fits a certain type of definition, then it makes sense that they're gonna target that type of energy for that specific procurement. But as a general rule, the broader you can be, the more likely you are to have better competition. And in the end, better competition generally results in better outcomes for the customers.
That was helpful. My intended question was, is there a way to accomplish both? To say what you think you want, for example, solar or battery or whatever, but still have it be an all source. So you're referencing to your IRP and the specific technology that you think you want, but you're open-minded enough to ask for bids that could be made up of other technologies.
I think that's exactly correct. We are currently engaged as an independent evaluator for an all-source RFP, and that utilities IRP and the RFP. The RFP itself specifically says our IRP said we need this, this, and this, and then it said please submit your bids, and in that RFP. They received a number of different types of technologies that most of them generally met the needs as identified in the IRP and as specified at the front of the RFP. But they received some bids that didn't necessarily fall into one of those categories. And with the exception of additional processing time to incorporate that bid into your methodologies and to understand how it would fit onto your system, even if you reject those bids that didn't necessarily meet your initial need, there's no real harm done. And in fact, the utility then has greater insight into the wider market. Oh, there are bidders out there who want to do this type of stuff, these types of technologies, these types of contracts, and it just leads to a greater market knowledge at generally very little cost.
I have just a couple more questions, and you just referenced that PA Consultant is currently serving in the role of an independent third party. Does that experience inform your recommendations to us? Does it bias you toward an independent third party?
If it does, it doesn't bias our recommendation towards PA Consulting as that independent third party. I just know that in working around the country for the last 30 years on resource planning and procurement support, we have seen that areas and we certainly haven't been engaged in even a majority or even close to a majority of all the states, all the jurisdictions that do require it, but we have observed that it tends to lead to a better, more open process. In general, when entities know there's an independent evaluator or observer or auditor, it tends to improve their process. And I think that that has been shown in many studies. There's a reason. I think we identified up to about a dozen states. I'm sure that there are more jurisdictions that require this type of role for their procurements, because at the end of the day, the commission and the commission staff have limited resources. They have multiple utilities that they're overseeing, and you're simply unable to dive into every single procurement. But having an independent third party that you believe is working to safeguard the interests of the customers, it's going to lead to better outcomes. I would say that in the engagements that we have been a part of, we have on occasion found spreadsheet errors that we pointed out to the utility. We have found cases where we disagreed with the utility's interpretation of a bid or interpretation of a clarification response, and we're able to raise that and talk it through with the utility to say we think you're getting this a little bit differently than we take it, and just having that additional level of oversight and observation generally is going to lead to better outcomes for the customers.
Earlier, I thought I heard you say that the cost of that was hundredths of a percent. Later on, I think I heard you say something else that I won't even try to recall. Would you address the cost and also kind of the return on that cost?
Identifying the return is certainly not an easy answer. It's very difficult to point to increased competition as a quantifiable metric that you can identify a return, right? But in general, I do know that developers, when they have reason to believe that a process is going to be fair and unbiased and transparent as possible, they are going to be more likely to participate in that RFP. That makes a lot of sense, right? It's difficult to talk about specific costs because they tend to be confidential. I can't speak to our contract with our current utility that we're working with. It's a confidential number. But I can say, as I mentioned earlier, if we think about let's say the 1,500 megawatts of solar that Santee Cooper's IRP has identified as a need by 2030, I believe it is. 1,500 megawatts of solar, that's a very significant investment. That's going to be on the order of, depending on, a PPA, or Santee Cooper's not going to be procuring to own the resources. So on the PPA, it's hundreds of millions of dollars, could be approaching over $1 billion for 1,500 megawatts of solar. So if we think about an independent observer contract, it's going to be in the range of 3, 4, 0.05% of that total procurement cost. And so that's the cost benefit analysis right there, right? As you think about the total cost of a procurement and the cost of the ability for the commission to have comfort that it was conducted according to the program guidelines that you all will have approved by that point, it follows that it's as I called it earlier, it's cheap insurance.
I have a tiny last question, and it's on page 11 of your report, and I'm sure it's from Santee Cooper's IRP, but you talk about economy purchases being 26%.
Yeah.
What are they? Is that a PPA? Is that, I don't know.
It will. I believe that would be, and we had taken that information, I believe, from the IRP itself. That's along the lines of, sort of trades and bilateral energy purchases, not necessarily contracted with a specific resource.
Thank you. Appreciate your patience and all of the answers. No
Thank
further
you.
questions.
Thank you, Commissioner. Commissioner Thomas? Oh, I'm sorry. Wrong light. Vice Chair Powers.
Thank you. And good morning.
Good morning.
I know the other commissioners have some questions, probably a lot smarter questions than I have, but I wanted to talk to you about your, and I guess I'm looking just at Ms. Campbell's rebuttal testimony and your summary of it. It's on page 19 of your report. In your summary of it, that it seems that there's some question that particular code section 5837-227 had a lack of clarity around industry definitions and the role of a third party. Is that a criticism of the statute by Ms. Campbell, or do you agree that there should be other language that would clarify this, or is it a problem?
Do I agree that there could be other language in the Act, in Act 90? Well, what I would say is it was clear that Act 90 did not mention an independent evaluator or observer, right? There was no mention of that. So I don't think it's a lack of clarity. I think she was just noting that Act 90 does not even contemplate it. However, I would say our view was that Act 90 also says that the authority can only approve this program, the applicant's program, if it believes it's in the best interests of Santee Cooper's customers. And I think that in our view, that gives the commission a bit of latitude in identifying exactly what the program needs to contain and what you all would like to see it contain, given that you have oversight and authority over these procurements. And so I think that while Act 90 is silent on the concept of an independent observer, I think that it doesn't preclude the commission from introducing that concept and requiring one.
Okay, and I'm sure not just Act 90, but Act 62, you're familiar that our legislature encourages renewable resources.
Yeah.
And further down, I think the last paragraph of Ms. Campbell, of your summary of Ms. Campbell's, that a third party should be determined once a need is identified. You mentioned earlier that, I think your term was better outcomes. And I've been trying to do some real estate searching, and better outcomes require timing. And mine has not been good trying to do that. Does that mean that an independent third party should be identified in advance, kind of in the stable, ready to go, or already committed to looking at things?
Thank you. That's a good question. What we have observed in other jurisdictions is typically when there is an RFP pending that would meet the requirement threshold for an independent observer, that the independent observer is typically contracted with prior to the kicking off of that procurement process.
Wouldn't that also be necessary, because I think there's some question that the utilities should have significant involvement because of their knowledge of their own system? Shouldn't an independent third party have that knowledge ahead of time or be aware? I mean, you say your company's serving as one. Do you feel that you have the knowledge of the needs of the system, the modeling inputs, the different things that that particular utility you're serving, you feel like you have sufficient knowledge of that?
Yes, sir. That's typically part of the process. When an independent observer is engaged, they often will meet with the utility, communicate with the utility to get an understanding of that system. Typically the observer already has some foundational knowledge of the system. That's how they got hired in the first place. But then then they will often work, communicate with the utility to define the evaluation criteria and evaluation methodology for the RFP. Now, when I say work with the utility, I mean, in general, understand what the utility plans to do in the RFP. In some cases, make recommendations, in other cases, not. But in all cases, document the understanding of how the utility arrived at those evaluation criteria and methodologies, so that they can later then report to the commission that it was done in a fair and transparent manner. And I would also say that in a number of jurisdictions, there's a more involved process between the public and the commission and the utility as the RFP is being designed. Santee Cooper mentioned that it had a stakeholder process in its 2020 RFP process, and they issued an RFI, request for information, prior to the RFP, and they got a lot of good feedback and insights from the stakeholder communities around what the RFP should look like and what it should request and things of that nature. We noticed that the program does not specify any stakeholder process, and again, that would be another area where an independent observer would recommend in advance of the RFP release that there is some sort of recurring stakeholder process to get an understanding. Times change, everything changes every year, all the time, to get an understanding of what the community and the stakeholders feel and what they would like to see as part of the process.
Well, it seems to me that this RFP and different utilities, it's a competitive process that a third-party administrator would need to be on board ahead of time to know the things I mentioned earlier about the utilities' needs and that sort of thing.
Well, you're absolutely correct, and I'd like to point out your use of the term third-party administrator. And I think that as we saw, as I understand it, the 2020 RFP, Santee Cooper worked with a consulting firm to help them administer the RFP. And certainly, if they're going to be involved in the modeling of bids, if they're going to be involved in the due diligence around the viability and the prepared readiness of that bidder and that project, they have to be very involved, and they have to probably be on board beforehand. But our recommendation is not for an administrator of the RFP. It's not to work with the utility to conduct the RFP. It's to provide an observation of the entire procurement process, to provide an after-the-fact report to the commission on what they observed during, to make sure that the utility and its third-party administrator to whether or not they followed the rules, whether or not it was fair and unbiased, and whether or not the bids were evaluated according to that methodology. So there is a distinction there.
Okay. and there is timing in the whole process.
There is timing.
Okay, thank you very much.
Yes, sir.
Thank you, Vice Chair. Commissioner Justin Williams.
Thank you, Madam Chair. Thank you, sir, for being here today, and thank you for your report.
Good morning. Thank you.
It's good to, it's interesting that you all are our consultant, because if I saw you on the street, I would walk right past you and not even know who you were. So the separation I can sort of appreciate, because it is definitely something that allows me to take an approach where I haven't had the real opportunity to talk with you about this, or any opportunity to talk to you about this, except for right now.
Yes, sir.
And so because of that, I hope my questions are not too pointed or rigid. I'm just trying to get a better understanding of what you're saying here. I am a bit confused about the recommendation for an all-source procurement plan for a CPRE program. It is very confusing to me. It just doesn't make sense. And I don't know if that's because of my inability to understand, or are we talking about two different things? Could you help me understand why a recommendation for an all-source procurement plan for a CPRE makes sense?
Sure. I understand the question. I would say that the phrase all source generally means all technologies available, any type of technology. And recognizing that this is procurement of renewable energy, it may be that that the RFP may not be able to be an RFP coming out of this program may not be able to be, fully all source. Our point and our meaning behind that recommendation was, again, we have not seen any program, any guidelines from Santee Cooper. I don't believe they've been required to submit any related to procurement of non-renewable energy. Right. I haven't seen a comparable Act 90 asking for a program around all source or thermal technology procurement. This was specific to renewable energy. But it was our feeling that the commission has an opportunity here to lay the groundwork and establish the framework for future RFPs of all types. And be able to define how those procurements need to proceed going forward. And even if we think about, say, a battery, a bulk energy storage system, for example, I believe Act 90 specified that batteries could only be included in the CPRE if they were fully charged from a renewable resource. And typically we would phrase that as sort of behind the meter of a given renewable facility. It's going to charge the battery directly from that renewable facility. But in many cases, if a battery is to be the most effective, it often would charge using grid power as well. And in this case, that would be an example of an effective resource that may be very effective for the system need of Santee Cooper, but it would be precluded from a very specific targeted RFP based on these program guidelines. So again, I go back to our view of Act 90, where the language states that it's the commission needs to consider the best interests of Santee Cooper's customers, and in the case of the all source versus a very targeted RFP, you may have the ability to request that the program be revised, the guidelines be revised to address other sorts of procurements beyond just the very specific renewable energy.
I understand that. So help me understand how that is not an overreach, considering the General Assembly was very specific about the Commission's role in approving a competitive procurement of renewable energy.
I'm sure some people may consider it, depending on their perspective, to be an overreach. But again, I would go back to the language of the best interest of Santee Cooper's customers, and you all have the ability to act within your authority and your oversight capabilities to specify certain things. Act 90 was specific to renewable energy, but it also was not very specific, even with regard to renewable energy. And I believe that the intent of the legislature was to give the commission the authority to regulate and oversee Santee Cooper's procurements in the best interest of Santee Cooper's customers.
Commissioner, may I ask a clarifying question?
Sure, you're the chair. You do whatever you want.
Mr. Janusek, you just said that Act 90, repeat what you said about Act 90 was specific to competitive procurement or something along those lines.
Well, Act 90 had basically...
That's only one part of Act 90, right?
The specific section that we're talking about, the
Okay.
5831.
I mean, Act 90 was broader than that one specific section.
Absolutely correct.
Okay, maybe I
Absolutely
just
correct.
maybe I
meant to-
misunderstood. I may have processed what you said incorrectly, but
Right.
okay.
Fair enough. Specific to 5831-227.
Okay.
It was specific
Just
to
that
the
one
renewable
statute.
energy. Yeah.
Okay. Thank you. I'm sorry. Thank you, Commissioner Williams.
Anytime, Madam Chair. So essentially, if I understand you correctly, sir, what you're saying is that your interpretation of the CPRE portion of Act 90 gives the Commission an opportunity to expand Santee Cooper's RFP or expand the Commission's regulation of Santee Cooper to include not only procuring renewable energy, but other sources of energy as well.
I think I would be careful to talk about expanding their authority. What I would say is that within the program guidelines that are being called for, I don't think there's anything that precludes the Commission from asking for information about how Santee Cooper would conduct other types of procurements in addition to renewable energy,
And why would we do that?
if it's in the best interest of Santee Cooper's customers.
So we would use the CPRE program to go on an exploratory quest or fishing expedition about RFPs outside of renewable energy and use the best interests of the customers as our reason for doing so?
I think that I wouldn't characterize them as a fishing expedition, and it may be that to the extent that, as I mentioned earlier, if Santee Cooper were to issue an all-source RFP, not targeted to renewable energy, but an all-source RFP, that doesn't mean that they are going to be bound to procure non-renewable energy. But as I said, if they, as they issue an all-source RFP, they could very well get some bids that are non-renewable energy and gain insight into the market, gain insight into what's out there and what the pricing is out there, and issuing an all-source RFP just generally is going to raise the level of competition. It's going to raise the level of market participation in that RFP, and I don't think that that is inconsistent with the intent of that section of Act 90.
Understood. I appreciate that, sir. I want to transition to the third-party reviewer. I think that's the term of art you used. Are you able to provide any quantifiable, tangible net benefits to Santee Cooper's customers by using a third-party reviewer?
As I mentioned earlier, I think quantifiable in terms of some quantifiable metric is difficult to discern. But I think it is generally that it's reasonable to assume that as developers and as the stakeholder community, as they see a process that they have every reason to believe is very fair and unbiased, and has an observer who is going to be watching the communications, evaluating the communications, evaluating the process. When they see that, they have much more confidence in the procurement to begin with, and they're going to be more likely to participate in that. Now, that doesn't mean that it may be that every developer in the state who has the ability to bid into a procurement is going to bid in anyway. So the level of competition may very well be there regardless, but it may not be. And further, as I said, having a third party who is watching the communications and watching the evaluation methodologies, they may very well uncover issues that had been missed by the utility or even the utility's third-party administrator. That has definitely happened in my experience, and even one of those instances lends credibility to the concept that having an independent observer adds value to the process.
Understood. Thank you for that, sir. Are you aware if anyone anywhere, specifically in the state of South Carolina, has accused Santee Cooper of being unfair, biased, or opaque in their RFP process?
I am not aware.
Okay. Considering that, and neither am I, and so considering that issue has not been raised, and considering in other proceedings there have been questions or concerns when they have existed, to my knowledge, they've been raised in some way, shape, or form. Considering we don't have that here, how would you justify the expense to Santee Cooper's customers other than just providing additional comfort?
Well, I think it's not a case of just providing additional comfort. I think it's providing additional another layer of checks and balances, right, and another layer of evaluation to make sure that that nothing was missed or that there were no mistakes made. And I think that there's a reason that the commission engaged PA Consulting to review this plan. It's essentially the same, very similar concept. You all hired us to review this plan and provide our thoughts and opinions and potentially recommendations on this CPRE plan. And there's a cost benefit to this process, just as there would be with independent observers of procurements. And the difference being that procurements are involving hundreds of millions of dollars of commitments by the utility.
When you say hundreds of millions of dollars of commitments, over what time period are you referencing?
Well, generally, by and large, typically power purchase agreements, PPAs, are going to run anywhere between 20 and 30 years in length, typically tied to the life of a facility. And when we talk about the IRP's need for 1,500 megawatts of solar energy by 2030, that level of solar generation for that many years is going to run into the hundreds of millions of dollars.
Are you concerned about the expansion of solar generating facilities in South Carolina?
Am I concerned?
Mm-hmm. And I'm referencing the portion of your report that speaks to, I'm looking for it now, renewable energy risk. I'm scrolling through. I'm going to give you a page number here shortly.
Sure.
I think my friend here is pointing me to page 25. Let's see, is it 25? Yes, sir, it is. Thank you, Commissioner Caston. Renewable energy generation risk. It seems that you go over several risks, but I'm not picking up the connection to South Carolina directly. So the risk that you identify on page 25, have you identified South Carolina being in a position to experience those risks, or more specifically, Santee Cooper's service territory?
I think that in general, any utility service territory is subject to these risks. When we look at the nodal the nodal price basis, that's generally reserved for for organized settlement markets where generators are paid at their given interconnection node and based on what that looks like. But the concept still applies even to Santee Cooper. If you've got a lot of transmission congestion in one particular area, and if you locate a facility there, you're gonna receive less benefit from that facility because of the congestion. You may have to curtail it. So that certainly is very likely to be a consideration even in Santee Cooper's territory. Looking at the intermittency and the weather risk certainly is going to be in play here as well, and the shaping of the generation versus the load shape of Santee Cooper. In many cases, Santee Cooper probably has needs in certain hours, particularly as you get into the evening hours, where the solar generation may not be able to meet those needs, and on a declining basis as the day goes on. That's a risk factor that needs to be incorporated into the evaluation methodology as well.
Understood, and thank you for sharing that. So, beyond the general application of these general principles that could possibly apply to Santee Cooper, did you perform or do you have information specifically as to whether or not Santee Cooper's service territory is experiencing transmission congestion?
I do
Based
not
on-
have any specific knowledge about Santee Cooper transmission congestion, but I would say that in my experience, it is highly likely that they do have pockets of congestion, just given my experience and my general knowledge of how transmission systems work. The whole issue is that localized transmission networks and localized resources sometimes come into conflict with each other in terms of congestion.
Have you identified or do you know if Santee Cooper service territory has a high penetration of renewable energy generators?
I would say that in general, depending on how you characterize high, they have a fairly low penetration of solar in Santee Cooper's territory. And that's generally informed by their very own IRP and the amount of megawatts of solar capability that they've identified that they have, I would characterize as a low penetration.
Okay. So the risk of energy prices spiking due to regions with high penetration levels when renewable output is very low. And here you say when energy prices tend to spike and when renewable output is high, energy prices often are suppressed. That's not something that is a risk in Santee Cooper's territory based on what you know?
Not today,
Not today.
but as penetration increases, it can become a factor. Which I think is another sort of reason for our discussion around looking for specificity in the RFP processes that's in these program guidelines, so that the commission can put into place requirements around analyzing that risk in RFPs going forward.
Thank you, sir, for your answers. I thoroughly enjoyed reading your report. Madam Chair, that's all I have.
Thank you,
Thank you,
Commissioner
Commissioner.
Williams.
Commissioner Caston.
Thank you, Madam Chair. And still good morning.
It is good morning. Thanks.
I'm pretty much going to plow some of the same ground, but it's for my edification. Relative to the third-party discussion that we've had a lot of this morning, if Santee Cooper does this on their own, in some form that they feel is appropriate, and ORS, has statutory authority to review, such as this, does this seem reasonable to you?
I want to make sure I understand the question. If Santee Cooper does it on their own, but I didn't quite catch the ORS reference.
Well, ORS has the statutory authority to review Santee Cooper.
Mm-hmm.
So if they contract with a third party to help them with the process, and I know your focus, you say, is really after the process to see was the process done well. And on the one hand, I would think, well, if it's after the fact, it's probably too late anyway. But at least we'll know that it was too late. So what I'm asking is if Santee Cooper chooses to use a consultant to help with the process, and the Office of Regulatory Staff reviews that process, not just that process, but kind of tea to green of the process, the outcome, the dollars, the numbers, and everything else. Is that a reasonable, is that reasonably enough transparent and open?
I think it certainly could be. I was unaware from reading the testimony about the 2020 RFP. I was unaware how involved, if at all, ORS staff was involved throughout the process. When I mentioned after the fact, that was in reference to a report after the fact, providing info to the commissioner. But in general, the independent observer would be involved throughout the process, and at the point of uncovering issues, would be in a position to raise it to the utility and the commission and say, we think that this part of the RFP could be improved before it hits the street, before it goes out to the public. So be able to make recommendations in more of a real-time nature. And to the extent, if that's what ORS staff did on the 2020 RFP, and if they were involved observing the communications and the details in real time, then that process could very well work for the commission to be able to gain that understanding of whether or not the process was conducted fairly and in accordance with the methodologies described.
Understand. And ORS really only recently has this statutory authority. You understand that, correct?
Yeah. Mm.
Okay. I'm going to bring up elongated discovery process again, but I want to make sure in my words what I think I heard you say, and that's it. I understand you to mean that the RFP process or the program guidelines should have as much detail as possible to eliminate as much Q&A as possible. Because of the lack of detail, will simply generate more time and effort. Is that a correct understanding?
Correct, with one addition. The more the information that is documented in the bid submittals versus what is uncovered through subsequent Q&A, it becomes less objective. If Mr. Painter referenced in his testimony that Santee Cooper would have both oral and written communications with bidders to clarify certain aspects of their bids. And to the extent that it is sometimes impossible to characterize the nature of all of those communications without reading every single email and without being on every single phone call, then we have a departure from the specific documented information that was in a bid package versus what ultimately was used in the evaluation. And then it becomes an exercise of tracing the pathway through those communications, how they got from what was submitted to what was actually used in the evaluation.
Okay.
And that's the job of the independent observer, is to do that tracing.
Okay. And relative to all source. And if I'm wrong, say, no, that's not what I mean. What it sounds like I'm hearing is PA believes all source RFPs make more sense and in the best interest of the customers, as opposed to just having a specific technology-centric RFP process. Or is that what I'm hearing?
With some exceptions, yes. I mentioned that there are certain types of procurement that may be better served if they are very targeted. But as a general rule, all source procurements tend to provide better outcomes, lower prices, and better insight into the wider market that the utility is operating in.
Okay. Good enough. Thank you, Mr. Jennison.
Thank you, Commissioner Caston.
Thank you, Commissioner Caston. Commissioners, any further questions? I have just one. I think everything else I had has been asked. Mr. Janicek, I note in your conclusion on page 34, under section 5.1, there's a statement that the research team concludes there are no non-compliance concerns with the guidelines. Would you explain that to me, please? Non-compliance concerns.
I think that that's correct. I think that if you look at the minimum requirements of that section of Act 90, you could conclude that Santee Cooper, their proposed plan was in alignment with those requirements.
Okay. That's what I was reading that as, and I just wanted confirmation on that. I appreciate it. Thank you. Commissioners, anything further for the witness while we have him?
Madam Chair,
Commissioner Justin Jones.
I just wanted to thank the witness and PA Consultant for the report. It's good to have something like this to consider when we're trying to figure out the right path for South Carolina's energy future. So I appreciate all your hard work. Thank you.
Thank you.
Commissioner Carol Lee Williams.
Thank you, Chair Belzer. When Chair Belzer took us back to page 34, I saw a big question mark at 5A and wanted to ask you to give us more of what you had in mind with the statement related to, as such, stipulated requirements should also be outlined within the guidelines to cover a variety of resource types. And what I feel about the circumstances that we've had a lot of, that Santee Cooper put forward those guidelines, and we've had a lot of eyes and minds looking at it, and that, you know, I think it should evolve a little bit. I think there have been some insights that have been raised that are good, and there's clearly a stipulation that reflects some of that as well. So having said that, what did you mean by 5A?
Well, I think that what we meant was, again, it goes back to Chair Belcher's question around did the plan meet the Act 90, this section of Act 90's requirements? and you could conclude that it does meet the bare minimum of those requirements. However, we believe that the intent of the legislation was to ask Santee Cooper to give the commission a very fulsome plan about how it was going to conduct these procurements. And when we read the initial draft of this plan, we see a lot of language around the timing requirements, notifying the public 90 days in advance and releasing a pro forma RFP 45 days in advance. But it doesn't go much beyond that. It doesn't go into the details of what those RFPs are going to contain. And I think the commission, I don't believe that the intent of the legislation was to see a relatively brief plan which basically parrots back the requirements of Act 90. I think the legislation was looking for much more detail than is contained in this plan, and I think the commission would need and want much more detail than what's in this first draft of this plan. I think that the plan, it gives you all the opportunity to, again, lay a foundational expectations for what RFPs are going to need to contain going forward. And there's just not a lot of that detail here in this plan. To their credit, they do list a number of factors that would be considered in the evaluations of bids, but no detail around any of those factors. And again, in other jurisdictions that we see, there's a very public process, a very public process around what an RFP is going to look like. In some jurisdictions, the commission has to approve the RFP, before it gets released to the public. And I think that I'm not necessarily recommending that, but I do think that the commission and the Santee Cooper's customers would be better served by program guidelines that are more specific than what we've seen here in the plan. So that's what I meant, in terms of 5A, we would just like to see more specificity around, even within renewable energy, as an umbrella term, renewable energy, there's a number of different information types that would be needed for batteries, for wind, for solar, for other types of renewable energy. And the plan was fairly silent on any detail in that direction.
Thank you. And I just noticed another note that I've got in the document, and it is on page 20. And at the end of the stipulation summary and the beginning of the question and answer hearing section, this is more procedural. But I just wanted to, and I may need some help from the chair, but I just wanted to clarify that when we heard this on June the 12th,
something like that.
We had an evidentiary hearing, and we did not forego it. And I just wanted to clarify, just for the record, that that last sentence in 3.3 and that beginning sentence in 3.4, let's see. It was more than, we did have a question and answer session, but we really had a full hearing on this topic.
Understood. It may be semantics.
Okay.
We had, when we watched the hearing, it seemed as though it was a little bit different than a very more formal hearing. It was more of a Q&A session. Apologies for the use of the word forego.
Well, I didn't mean it in a I just wanted the record to reflect that I did not believe that we conducted this hearing any differently than we would have otherwise. Chair Belser, would you like to add anything to that or correct me?
No, I picked up on that too, and I was like, maybe we weren't in the same. Well, they were in the room, but we may be a little more informal than some. We are very formal when we need to be, but if I can relax that at times, I want everybody in the room to be very comfortable.
Understood, and we did get a lot out of that Q&A session and understood the back and forth, and in fact, we referenced it in our report around. There was a lot of discussion around the different definitions of this independent observer concept that we're talking about here.
Thank you.
I'd like to follow up on a response to Commissioner Williams's first question with regard to 5.A. Again, you referenced the evaluation methodology that's contained on page 12 of the proposed guideline. Given the identified need, whether of a renewable resource, it could be location, it could be type, whatever. Could the weights given to those different criteria that are listed, could those change given the identified need and what the utility needs? Like you might weight number one very high. Well, reliability always probably going to be high, but say number 4, location. Depending on where it's located, that may rate high in one procurement, but not quite as high as in another procurement.
Absolutely. What I today had been careful to avoid discussion of weighting between those categories. What we were getting at is it's just a list of 15 items with no description of those items. Many of them are just one word. What we would be looking for and what we think the commission would benefit from is a description of how are you going to measure readiness or viability, for example. And I think that that how would you, that would apply to any RFP. There's no reason why that can't get set into these program guidelines to say, for all RFPs, we are going to do this, this, and this to measure readiness, this, and this to measure viability. There are a few of those factors that may require different how would we's depending on the nature of the need, but in general, they could still be described better. And I think it would give the commission and the public better comfort that that these are methods that have been vetted and approved by the commission in advance, rather than put into an RFP without any review by the commission. As I understand it, if this program as written is accepted, then you all, the commission and staff, will not see the content of an RFP until it is released to the public. Is that correct? And so there's nothing here that requires Santee Cooper to describe its evaluation methodologies more clearly until it actually releases an RFP.
Okay, I get you now. Thank you for that. Commissioner Justin Williams, you like some?
Yes, ma'am. Want to follow up on one of the things you said, sir, in terms of some of your recommendations being applicable to any RFP. Understanding that you reviewed Santee Cooper's CPRA program here, some of the best practices that you mentioned, the third-party independent reviewer, more detail, and so forth and so on, is it fair to say that you believe that those should be a part of any RFP program, not just Santee Cooper. So it could be some of the utilities that you've worked with in other jurisdictions, or maybe other utilities in this jurisdiction. Or these are things you think are applicable across the board, or are they specific to Santee Cooper for some reason or another?
I wouldn't think that they're specific to Santee Cooper. And in fact, I would say that in general, the independent observer is probably even more valuable to the commission and to the customers of the state for private utilities, for investor-owned utilities, right? Because they've got other motives, and Santee Cooper being a publicly held utility, by and large, is going to have the best interest of the public in mind in all cases. It works for the public. It doesn't work for private shareholders. So, in general, I would say that it's probably more applicable to privately held utilities more than publicly held. However, the just the simple nature of having an independent observer that the commission can rely on to provide unbiased opinions about the whole process is going to give developers increased comfort in the process, and it also could potentially uncover issues that maybe hadn't been caught by the utility or its administrator.
Thank you, sir. Thank you, Madam Chair.
Thank you.
Thank you, Commissioner Williams. Commissioners, anything further? Mr. Janasek, thank you very much. I too appreciate.
Madam Chair, I apologize.
Mr. Mustian?
Could I ask just a couple of clarifying questions? I don't think this will be contentious, just very briefly, in response to Commissioner questions, specifically Commissioner Caston's questions about Act 90 and ORS's review.
Any objection?
No objection from Santee Cooper.
Mr. Mustian?
Mr. Janasek, I think it's still good morning, so thank you.
Good morning.
I just wanted to make sure that I was clear on, you had a colloquy with Commissioner Caston about Act 90, and I think you talked about ORS's review of the 2020 RFP. Do you recall that exchange?
Mm-hmm.
And when you were talking about that, Act 90 did not become effective until June of 2021, and so I wanted to make clear, or were you talking about ORS's review under Act 90, or was that, I believe there was a limited review under Act 135, which preceded Act 90. Do you recall that?
What I said is that that the testimony that we read did not go into any level of detail of the ORS review of the 2020 RFP, if there was one.
Okay. All right. Very good. Thank you, Madam Chair.
Thank you. I wasn't going back to the parties because he's kind of a commission witness, I suppose, but is there anything else, Ms. Brazil?
No, Madam Chair.
Okay. Thank you very much. Now, thank you very much for being here today. I too appreciate the report that y'all submitted. It was a good read. I enjoyed reading it, and thank you for your testimony today, and you may stand down.
Thank you.
You have somebody with you. Do you want to introduce him to us?
I will. I have Derek Hasbrook with me as well. Okay. Derek's a colleague of mine at PA Consulting.
I think his name was in the report, was it not?
It was.
Okay. Thank you. Welcome, Mr. Hasbrook. Thank you. You may stand down, Mr. Janasek.
Thank you, Commission. Thank you.
Before we take rebuttal testimony, can we take a 10-minute break, please? Thank you. Let's come back at 12 o'clock by Apple or Verizon or whoever this time is here. Not by that clock. That's a little fast. Good afternoon and welcome back to the Public Service Commission as we continue in this proceeding in docket number 2022-351E. Let's take a roll call of commissioners. Present in the hearing room, we have Commissioner Justin Williams, Vice Chair Powers, Commissioner Thomas, Commissioner Carol Lee Williams, Commissioner Caston, and and Chair Belser's in the hearing room. And with us virtually is Commissioner Irvin. We have finished hearing from the independent consultant, and now we will recognize Santee Cooper.
Thank you, Chair Belser. At this time, Santee Cooper calls Jane Campbell to the stand.
Ms. Campbell, if you would raise your right hand, please. Do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Okay.
Thank you. Yes, thank you. I was just letting Ms. Campbell get adjusted with the microphone. Ms. Campbell, please state your name for the record.
Jane Campbell.
And by whom are you employed and in what capacity?
I am employed at Santee Cooper as the Senior Director of Resource Planning.
Thank you. Have you prepared or caused to be prepared under your supervision rebuttal testimony of 6 pages that was previously filed with the Commission on September 1, 2023 in this docket?
I have.
Do you have any changes or additions to your pre-filed rebuttal testimony?
No, I don't.
And I've asked you the same questions here today. Would your answers be the same?
Yes, they would.
Chair Belser, at this time I move that the pre-filed rebuttal testimony of Ms. Campbell be admitted into the record as if given orally from the stand.
Ms. Campbell's rebuttal testimony will be received into the record as if given orally from the stand.
Ms. Campbell, have you prepared a summary of your rebuttal testimony?
I have.
Would you please deliver that summary at this time?
Of course. So, good afternoon, Chair Belser and Commissioners. In my rebuttal testimony filed on September 1st, I respond to the recommendations on page 34 of the report provided by PA Consulting in this docket. While Santee Cooper agrees with certain statements and recommendations made by PA Consulting, the recommendations relate more to the RFP stage of a CPRE process and are not intended for the proposed program guidelines that were submitted by Santee Cooper to the Commission on November 1st of 2022. As previously explained in this docket, the proposed program guidelines provide the process by which Santee Cooper would fulfill an identified renewable need via a subsequent competitive solicitation or RFP. Santee Cooper will develop an RFP consistent with the program guidelines, and the RFP will contain the detailed information. The RFP would proceed in accordance with the timeline in Exhibit A of the application in this docket. Additionally, Santee Cooper disagrees with PA Consulting's recommendation that in all situations, an independent observer be appointed or engaged in addition to the third party that Santee Cooper may use to assist it with an RFP. This recommendation has been made without consideration of the costs and benefits of engaging an additional third party or any analysis justifying this departure from processes utilized by other utilities in South Carolina. This concludes my summary of my rebuttal testimony.
Thank you, Ms. Campbell. At this time, please answer any questions.
Thank you, Mr. Cooper. Office of Regulatory Staff?
No questions.
Commissioners, questions for this witness? Commissioner Carol Lee Williams?
Thank you, Chair Belser. Good afternoon. Hi, good to see you. My perspective on this is that we're all learning and improving and evolving as we go. And especially while this isn't brand new to you all, you have the experience and the expertise of one series. I guess I wonder if there's anything that you've heard that would suggest that a updated guideline to incorporate the ideas that you clearly want to embrace, or that you want to note will clearly be in the RFP, because I wonder if that would be advisable. And I don't know, given the stipulation, if that is just off limits, but in a sensical kind of way, to me, I would find more comfort if I could see an updated guideline that embraces what you've learned that you want to add, and maybe gives some specificity, recognizing that we're not in a position to review the RFP. So am I making, is that legally doable? Is it something that, that wouldn't be a question to you. Is that something that might make sense, given your goal as a government employee who wants to put out the best product and be most responsive and lowest cost and all of that? Mm-hmm. Would that make any sense to you?
I think we're always going to be learning as we go through additional solicitations. Certainly the guidelines were built upon a solicitation that was done in 2020 and incorporates learnings from that. I would say the guidelines are broad enough to allow us the flexibility to tailor a specific RFP to a specific situation. I will also point out that at the end of the process, and I don't believe this was brought up in today, there's a report that's filed with the commission, and it's 60 days after bids are awarded. And in that, we're required to review the process, notify all the bids that were posted, and I'll have to flip to the application on the specifics, but there is a follow-up report on the success of the solicitation and the RFP process that will not only be captured by us, but shared with you at the end of the day. But to answer your question, I would say that the guidelines as they stand today are in compliance with Act 90, give us the flexibility to tailor RFPs, and we may very well incorporate some of Mr. Janasek's recommendations in specific RFPs. And the guidelines allow us to do that, but I would not change what's in the docket at this point.
Even the items that you have agreed with?
Well, because we may agree for a specific RFP, but the next one may be different. Location may be very key for one RFP, or cost, or right, reliability.
So the agreements that you have indicated are ones that would be implemented in the RFP per your thoughts?
As appropriate.
Right. Okay. I think that is my only question, but I bet I'll be back after my colleagues have asked questions.
It's okay.
Thank you very much.
Is that Commissioner Williams at the end? That's his light is on, or Vice Chair?
Yes, ma'am. It's mine. Thank you, Madam Chair. Good morning, ma'am.
Hello again.
Hello again. Understanding that we heard your testimony regarding all source procurement versus a CPRE. Based on reading the report and hearing the testimony about the report today, has your opinion changed about specifically pursuing renewable energy through a procurement process compared to using all technology sources?
No, my opinion has not changed.
What about the thought of the commission using the CPRE language or Act 90 language that speaks to ensuring the best interest of your customers as to exploring or looking into Santee Cooper's procurement of other generation sources, excuse me?
I wouldn't say that in a situation where several technologies are similar in terms of the benefits they provide to our system, we wouldn't rule out opening up a procurement to different types of technology. But in a case where we've evaluated specific technology with specific capacity requirements, specific energy requirements that we need in a specific location and a specific size, it's very difficult to open that up to an all source or to other options. Our customers are going to be protected by the competitive process itself that we've presented here. And the participants of the market or the participants in that solicitation will bring good market intelligence to our solicitation. And then to the extent that that informs future IRPs or future annual updates, our plan would be to incorporate that information into planning processes going forward.
Stop you a minute. We've got a glitch in a little
Okay.
hold up in the back.
Testing 1, 2.
Has that got it? Okay. I'm
Can
sorry.
you hear me okay?
Yes, ma'am. I'm sorry we interrupted.
That's okay.
Excuse me.
Yeah.
Do you know where you were in your thought?
I think so. So a specific solicitation is going to be typically for a specific technology, but in a case where we would be able to entertain, say, solar, batteries, wind, we could tailor an RFP to do so.
What you're saying makes sense to me. What I'm trying to reconcile is why the consultant, the commission hired, and I believe the Office of Regulatory Staff take a different position. What is it that they're seeing that you're not seeing when it comes to the benefits of all source procurement versus single source?
Right. So I think coming from the perspective of having developed an integrated resource plan and done extensive modeling, evaluating different technologies and the benefits that each of those bring to the system, that the output and the recommendation is typically going to be very specific. So we're going to come up and say, yes, solar is a good decision. This is what we want to implement. If you open it up and say, I need 300 megawatts of any type of power, then the evaluation you've done in your IRP is not, I don't want to say worthless, but you almost have to start back over and redo the evaluation again to see if that makes the most sense for your entire system. What it does, though, is it informs your assumptions that go into the IRP. So if you're getting different intelligence on, say, a market solicitation that you may use in an IRP update, it'll inform you in future planning processes. Does that make sense?
The all source or the single source?
Well, no, a single source. So,
a single source.
Yeah, so if I went out for solar and I got back markedly different prices than, say, the assumptions that were in my IRP, then I would go and update those assumptions in the next run.
Okay. Do you have any? You had opportunity to read the consultant's report, right?
I did.
Do you have any comments about the discussion about the risk associated with renewables?
Yeah, there was a lot of discussion about transmission congestion, which I'm not the expert to speak about, but I will say that in order to participate in this, each participant will have to have a valid transmission interconnection agreement, which means they've said, we want to connect to your system at this location, and that's been studied and evaluated. So that's a you know, that's a bar they've got to get past before they can even participate in a solicitation. So I think that will put their project in front of the transmission system to see if there are any issues or if it's going to cost additional money in order to incorporate that project into our overall system.
All right, I think that's all I have for you, ma'am. Thank you. Madam Chair, that's all I have. Thank you.
Thank you, Commissioner Williams. Commissioners, Commissioner Thomas?
Thank you. Good afternoon. I just have one, just a high-level question. And basically, you've been here today listening, and we've all been listening, and I've learned a lot. But I wanted to just give you the opportunity, if you have anything else that you would like to add, but haven't been asked the appropriate question. Is there anything that you'd like to say? I just want you to have that chance.
Yeah, a couple things. So, first of all, as I was reading through PA Consulting's report, it was either 2 or 3 times in the report that he acknowledged that our proposed guidelines that we applied in our application meet the requirements of Act 90. And I don't think there's any disagreement with that from the parties involved. So that's important to point out. The other point was, and I mentioned this in speaking with Commissioner Williams, that there is a report that's filed at the conclusion of the bid process, which we will present to you, and we'll evaluate the process, the bids that were received, and the methodology that we used to select those bids, the final results. So that's not done in a vacuum. It's very transparent. So I think those are the only points I wanted to make.
Okay, thank you. That's all I have.
Thank you, Commissioner. Commissioner Caston?
Thank you, Madam Chair. Good afternoon. Does Santee Cooper choose generation types based on metrics such as reliability, least cost, and so on that are in the best interest of the customer?
Well, you're describing our integrated resource plan program. Is intended to identify the generation and the portfolio of generation that is the least cost and best least ratepayer risk, low cost and least ratepayer risk for our customers. And that's where, well, I think that's where the effort goes into identifying what's the best portfolio for our system.
Well, that was actually kind of my second question, so you've probably already answered it, but I'll ask it anyway. Is Santee Cooper's IRP development generation, I guess as you do your IRP, is it generation agnostic or is it generation direct?
Right, so we are going to study all technologies that are available when we develop our integrated resource plan. We are going to look at the cost of those technologies. We're going to look at the environmental attributes of those technologies. We're going to look at the reliability of those technologies. We're going to look at all those different things as we do different analyses, and you'll see that when we are here again in December. Cost is important, but so are all those other things that I mentioned, and those are what drive our recommendation as far as the portfolio Santee Cooper wants to proceed with. So when you get to that point, yes, it is generation specific to the extent that, a technology might be very similar to another. I could see us doing a multiple source RFP or even all source RFP when they're similar. But often you get to that point and the characteristics that you've baked into your study are quite specific, and we'll end up with a technology. And in order to fulfill the requirements of the IRP and meet the expectations of the portfolio that you developed, you're going to want to go with that technology.
So what I think I'm hearing is that Santee Cooper does not go into the IRP with any preconceived notion, but these are the technologies out there. This is the demand we need. What's the best way to meet it? Is that correct?
Very well said.
And I've not heard you say this, but it sounds like what I'm really hearing or understanding maybe is that whether you call it a CPRE or a ABC or an XYZ, Santee Cooper chooses from the IRP the specific generation that they will need during this course of time, this next 5 years, this whatever it is, and produces an RFP that will help achieve that goal at the least cost. It's that true or false?
That's true.
So having said that, and I promise you this isn't a set-up question because I'm thinking the same thing. Well, I may not be thinking the same thing. I'm thinking this, is that being the case, and I think in Act 90, Santee Cooper is required to have a CPRE program. Absent that, Santee Cooper would continue just doing the RFP process that they use for the generation sources they need, period. Is that a true statement?
I think that's true. If you look back even at our 2020 solicitation, that was prior to Act 90, yet we still followed what I would call a competitive procurement of solar in that particular case. We had, I looked this up earlier this morning, we had 21 participants, we had 58 different projects that bid into that solicitation. So I would say, yes, it was very competitive, it was a robust response, and it gave us a very good idea what the market looked like when we made our decisions.
In an earlier statement, I think it was to Commissioner Jay Williams, I can't recall, but when it's talking about all source, and you made some statement like, if I need 300 megawatts of any kind of generation, which when I heard that, my first thought was, well, that would certainly be an argument for more specificity in an RFP process. But what I think I've deduced from this question and answer and hearing you respond to them is the IRP dictates where our RFPs are leading you. And those RFPs, are they specific enough? Do they have specific enough metrics and that we need X amount that's reliable, and the reliability metric is this, this, and this, and this? Is that accurate?
Yes, so typically your RFP is going to contain the information that your IRP used when it specified that particular type of generation. So if it's 300 megawatts of solar anywhere in the state, then that's what we would issue an RFP for. If it's 300 megawatts of solar in a particular location, our RFP would be specific to that. If it's 300 megawatts of energy in a particular location, and we don't care if it's solar or wind or some other type of renewable, then maybe we would issue an all source at that point. But my experience has been that going through the IRP process, because it's so thorough and so complex, that when you get to the point where you're getting ready to go out and bid for a particular type of generation, you know what you need and where it needs to go. Did I answer your question?
Yes, it did. I was thinking back to a previous lifetime, yes. I believe that's all I have right now. I appreciate it. Thank you very much.
Commissioners, any further questions for the witness? Commissioner Carol Lee Williams.
Thank you, Chair Belser. I warned you I'd probably have another one. There was discussion earlier about the stakeholder process that you used for 2020, and I wondered if you wanted to comment on your stakeholder process for the current guidelines.
Okay, right. So I was not in this role during the 2020 solicitation. So I'm glad you asked me to speak about the current guidelines. The application contains a timeline for the steps we would go through as we go for a solicitation. There's a notice given that we're going to market, and then there's a 45-day notice that contains a pro forma PPA. And then we receive comments on that information. So that would be, in my mind, what a stakeholder process would be. Anyone who's interested in this, here's what we're proposing to do. Tell us what questions you have. Tell us how we can expand upon that, and tell us how we should refine our eventual RFP, which is then issued after 45 days. So in my mind, that's the stakeholder process, because it's given the market participants an opportunity to weigh in on the contents of that pro forma document.
And that pro forma document is the RFP?
No, there's a pro forma PPA that's issued 45 days before the RFP is issued. So it's 2 stages.
But it would inform the RFP, because it would be a part of the RFP eventually.
Right,
okay.
But it's issued and then can be refined before the actual RFP is issued.
Okay. And do you know if in 2020 the stakeholder process, was it about the guidelines? I know you shared that you weren't in this role. Was it about the guidelines, or was it about the RFP or the pro forma?
I don't think that I've got specifics on that. Let me look at one document real quick. Yeah, so I don't know that I can answer your question specifically. I will say that there was a period of time where an RFP was issued, respondents were able to ask questions about the RFP in order to inform their response. So that process did occur.
And that's a lot different, in my opinion, than getting the input beforehand.
Right, and I don't want to say that didn't happen. I just wasn't.
Right. No,
wasn't in the role at the time, and the information I have in front of me doesn't go prior to the RFP, because that's not what I asked for.
I understand. I appreciate your clarifying and talking about what you do know. Thank you very much. No further questions.
Thank you, Commissioner Williams. Commissioners, anything further for this witness? Hearing none. Any redirect?
Chair Belser, I'd like to ask just a couple of questions. I'll be very brief, and if I may go over there, just use the Elmo for everybody's purposes.
Wherever you need to be. Would you turn that microphone on, please?
Thank you very much. Ms. Campbell, I'm showing you what is Exhibit A to Santee Cooper's application. Can you see that okay?
Yes.
And you see it says there are references to 90 days, 45 days. Do you see that on the left?
Yes.
And Act 90 is fairly specific on certain things and information they want you to provide 90 days in advance. Is that correct?
Yes.
So, for example, 5831-227B mandates that Santee Cooper must procure resources subject to the following. Renewable energy procured by the Public Service Authority shall be procured via competitive solicitation open to all independent market participants that meet minimum eligibility requirements. Is that correct? Subject to check.
That's correct, yes.
It shall issue public notification of its intention to issue a competitive renewable solicitation at least 90 days prior to the release of such solicitation, correct?
That's correct.
Okay. And then it has other things at 45 days. For example, that's where it comes in the pro forma contract to inform market participants of the procurement terms and conditions. That would be done 45 days. Is that correct?
That's correct.
And so let's talk about a pro forma PPA. A PPA just simply means a power purchase agreement, correct?
Correct.
And so depending on the need that you identify, either in an IRP or other utility planning process, you may develop a template PPA that corresponds to that need that you've identified. Is that correct?
That's correct.
But what the guidelines reflect in compliance with Act 90 is you're going to put that PPA out for participants to see, issue comments, and there may be additional tweaks or amendments to that PPA at that time, right?
Right. So if you see the 45-day notice and then there's a 2-week period for participants to submit comments to the PPA, then there's a revised PPA issued as part of the process.
And so this really helps illustrate the difference between guidelines and an RFP, right? The guidelines say we're going to provide a PPA that's pro forma, but the guidelines can't really go to much more detail because that pro forma PPA is going to be in response to what you've identified either through an IRP or a planning process, correct?
Correct, and it'll be specific and unique to that particular solicitation.
And so we see at each of these stages, there are specific times and, as you indicated, in actions that must be taken. So even after the RFP is issued, then you see that there's last date for respondents to submit questions regarding the RFP, right? So that also, in addition to providing that opportunity for specifics around the actual RFP, there are timing requirements that Act 90 has already put forward, correct?
Absolutely correct.
And so the company, by complying with these timing guidelines, is going to avoid an elongated discovery process. Is that correct?
Correct.
And then at the end, the Act requires two things at the end. It requires, and I believe you said this, but I just want to be clear, it requires winning bids to be selected in accordance with the public evaluation methodology, correct?
Correct.
So even if you didn't use, even if Santee Cooper conducted an RFP on its own with no outside consultant, you still are required by law to select bids in accordance with the published methodology. Isn't that right?
That's correct.
And then 2, it requires you to submit a final report to the commission summarizing the results of the solicitation. In your mind, does that ensure transparency?
Yes, it does.
And finally, my last questions. Let me see if I can zoom in. Ms. Campbell, can you see what I bracketed, not highlighted, but bracketed, and it starts with the commission may adopt?
Yes.
Okay. Just to help you, I'm going to read it, but please track it. I'm going to ask you if I read it correctly. The commission may adopt procedures to implement the requirements of this section and shall retain continuing oversight and approval authority over all aspects of an approved program. Did I read that correctly?
Yes.
So if these guidelines later should be updated, I mean, the commission still has jurisdiction. We would still come back before the commission for any updates to the guidelines. Is that correct?
Correct.
Thank you very much. No further questions.
Thank you, Mr. Cooper. Ms. Campbell, thank you for your testimony today. We appreciate you being here. You may stand down.
Thank you, Chair.
Is there anything further to come before us today? Hearing nothing, I'd like to thank everyone for attending and the witnesses for their testimonies. And with that, we are, we'll be notifying the parties of our decision via upcoming commission business meeting on this docket. So thank you very much, and everyone have a good day. We are adjourned.